Welcome to this comprehensive lecture on European data protection law and regulation, focusing particularly on the territorial and material scope of the General Data Protection Regulation, GDPR. This lecture covers key aspects such as the GDPR's territorial scope, data processing principles, lawful processing criteria, and special categories of processing, all essential to understanding the nuances of European data protection law. On territorial and material scope of the GDPR, definition and criteria. 1. Territorial scope. Article 3 of the GDPR defines the territorial scope of the regulation. The GDPR applies to any entity processing personal data if that entity is established in the European Union, regardless of where the processing occurs. 2. Establishment. The definition of establishment includes any stable arrangement or presence that facilitates consistent economic activities within the EU. Controller-processor relationship. 1. If a controller or processor has an establishment in the EU, the GDPR applies to their processing activities, regardless of where the processing takes place. B. Non-establishment in the EU. Guidelines 3/2018 on territorial scope. 1. Offering goods and services. Even if a controller or processor is not established in the EU, the GDPR applies if they offer goods or services to EU residents or monitor their behavior. 2. Monitoring behavior. Monitoring includes tracking individuals through various technologies, such as cookies, analytics tools, or other online activities. Application of GDPR to international entities. 1. Third countries, organizations outside the EU that process data related to EU residents must comply with the GDPR if they engage in the specified activities. 2. Transfer mechanisms. Compliance includes adhering to mechanisms such as standard contractual clauses, binding corporate rules, or other GDPR-compliant methods for data transfers. See material scope of the GDPR. And processing activities. The GDPR's material scope encompasses the processing of personal data wholly or partly by automated means or in a manual filing system. 2. Exemptions. The GDPR exempts data processing activities that fall outside the scope of union law, household activities, and law enforcement or national security tasks. Data processing principles. The GDPR outlines 7 key principles that govern data processing activities. Lawfulness, fairness, and transparency. 1. Processing must have a lawful basis, be fair to the data subject, and be transparent about its purposes. Purpose limitation. 1. Data must be collected for specified, explicit, and legitimate purposes, and not further processed in a manner incompatible with those purposes. Proportionality. Data minimization. 1. Data collection should be adequate, relevant, and limited to what is necessary for the purposes of processing. Accuracy. 1. Data should be accurate and up-to-date. Controllers must take reasonable steps to rectify or erase inaccurate data. Storage limitation retention. 1. Data should be kept only for as long as necessary for the processing purposes. Controllers should establish and enforce retention policies. Integrity and confidentiality. 1. Controllers and processors must implement appropriate security measures to protect data from unauthorized access, alteration, or loss. Accountability. 1. Controllers are responsible for demonstrating compliance with all GDPR principles, including documenting processing activities and conducting audits. 3. Lawful processing criteria. The GDPR outlines 6 legal bases for lawful processing. Consent. 1. Consent must be freely given, specific, informed, and unambiguous. Data subjects must have the ability to withdraw consent at any time. Contractual necessity. 1. Processing is lawful if necessary for fulfilling a contract with the data subject or taking pre-contractual steps at their request. Legal obligation, vital interests, and public interest. 1. Processing is lawful if necessary for complying with legal obligations, protecting someone's vital interests, or performing a task in the public interest, or under official authority. Legitimate interests. 1. Processing is lawful if it serves legitimate interests of the controller or a third party, provided it doesn't override data subject rights and freedoms. Special categories of processing. 1. Processing special categories of personal data, such as health, religion, or racial data, is prohibited unless exceptions apply. INFORMAL conclusion: European data protection law and regulation, particularly the GDPR, is a robust and comprehensive framework governing the processing of personal data. It emphasizes territorial and material scope, data processing principles, and lawful processing criteria to safeguard individuals' privacy and rights. Understanding these nuances is critical for ensuring compliance and protecting data subjects across Europe and beyond.